All right, everybody. Wanted to stop in and say good morning, Tarina. Good morning. Thank you for stopping in. Appreciate you being here. But thought, you know what? It's been a little bit. I don't think I've talked about this case since it began. But I wanted to, stop in and give some thoughts on what we've seen so far. So Anita Hilario, if you're talking about in this case, sentencing, she hasn't been convicted yet. This is a trial. She's actually on trial. She did not plead guilty. So she testified yesterday. The defense, I believe, rested. I believe is what we saw. I could be wrong. There might be a little bit more, but I believe they rested. And I don't believe the state. There had been in the opening statement, there had been a suggestion that the state might put on some additional information that was not allowed to come in without her testifying. So I don't know. We'll see if that happens. But I have a feeling it's going to be a short rebuttal case from the state, to which the defense, I don't think, will put on a rebuttal or won't put on much of a rebuttal. And then we're going to be having closing arguments today, I believe. So this case, as the judge said, by the end of today, the jury will have this case. And again, it's anybody's guess what they do with it, because, I think a lot of people don't understand, when this type of a case comes on, they're looking at the simple fact this child was left in the car. But there is some, there is, it's not a completely clear situation here, depending on how the jury decides to interpret the circumstances. So if the jury were to decide that this lady made a mistake and had no intent, and again, the issue at hand is her awareness. If she was aware the baby was there and said, "I'm going to just leave the baby in the car," and it was a conscious decision to leave the baby in the car. So this needs to be clear. If the jury believes she consciously left this child in the car, whether it was, which is what I believe she did, that it was like, I know the child's there. She's in a rush. She's trying to get inside. So she figures, I'll go back out and get her in a minute. She's sleeping. Then if she consciously made that decision, she's guilty. She's guilty of at least the child neglect charges. The manslaughter charges, a lack of duty of care. She's guilty of the charges. And then it becomes, what does the judge want to do with this? She's facing up to life in prison, okay, because of a charge like this, because it deals with a child and because the child lost her life. As many have said in chat, this is one of those cases where, I guess it's what the state was offering as a plea, that if the state wasn't willing to work with her on a plea bargain that she felt was reasonable, you don't plead guilty, you go to trial. Make the state prove its case, make 12 people get in that box, hear her testimony, and think, did this woman actually forget the child? Like, did this woman consciously leave the child? Now, if the lady did not consciously leave the child in, and she got in a state of mind, which can happen. Now, what I think in a case like this would benefit from the jury is, if you're going to make that argument, and again, I don't know if the defense is going to put anything else in, but I think that you'd almost have to have a mental health expert come in and talk about how the human mind works, that given the scheduling changes, that it's possible that she could have been driving and completely forgot she had the child in the back. That would be something that would help the defense here. But the defense didn't choose to do that. Perhaps it's expense. Perhaps maybe they felt like that would open up other doors and avenues that the state could come in with other evidence that they didn't want to have come in. So they thought, we'll just put the defendant on the stand and let the jury use their own personal life experiences to determine if what she said is likely or not. But in the event that she was not distracted by a phone, that she wasn't distracted by anything else, that there was not a conscious decision at any part that led to this child being left in the car. That's what the defense's defense is here, is that she legitimately forgot the child was in the car. Thereby, she could not formulate the intent. She could not formulate the recklessness needed. Now, the state, one of the reasons why a lot of you have said, why the heck is this prosecutor asking about all these things? Because one of the elements of manslaughter is duty of care. She had a duty to care for that child. She had a duty to feed the child, change the child's diaper, and all of that stuff. So what he was doing was establishing that she failed to do all of those things. Of course, we know that by leaving her in the car, but it's important for the record that it be established. Now, the only decision is does the jury believe that she made a conscious decision to leave that child in the car, and it turned out to be a reckless decision. And that's where the complication arises, where many people think to themselves, oh, this is an easy open and shut case. And it's really not, because of the fact that there has to be an act of some sort by the defendant that would rise to the level of recklessness. And you might say, well, that act is leaving the child in the car. Well, if she truly forgot that child was in the car, and it was just, hey, not normal that she has this child in her car, then there's the criminality of this. It's an accident. It's not criminal. And that's what her attorney was arguing. Let's see here. We have a comment here. I've got to make it a little bit bigger. Tarina says, I believe she is guilty. The child was left in a hot car. Who walks away and leaves a helpless baby in the heat to sleep? No way that is it. Well, I hear what you're saying, Tarina, but in a court of law, you have to fit whatever the circumstances has to fit within a statute. And that's what they're doing here. In the statute she's charged under is aggravated manslaughter. And then there's third degree unaliving. And then there's the child neglect, basically, where she was, leaving the child in a car. So the leaving the child in a car, this jury would probably convict her of, because she did that. But again, the question at hand is, did she intentionally leave the child in the car? And I know that's it's a very difficult thing to understand. And I mean, this jury may feel exactly how we all do, which is like, how could you do that? And as a father of 4 children, I don't know how you could do that. But, there's been moments where I've driven down the road and started to do something that was just never related to leaving a child in the car. But I can know that, if I'm doing something out of the ordinary, where all of a sudden I turn left and I just started driving in a direction, and I get there and I'm there. But it's far different than saying, well, you have a child safety seat in the back seat of the car. That's the part that's going to be really, like, for instance, and again, I was thinking about this the other day. I was dropping my son off at school, and of course, I have a newborn, so I dropped my son off at school, and I was thinking about going to the store. And for a minute, I was thinking about, like, I'm going to go to the store and I'm going to jump in. And I was thinking it was just me. But then, you know what caught my eye in the back seat? The child safety seat. And I was like, oh, shoot, I have the baby. And I'm like, oh, that alters my decision making on whether or not I'm going to go to the store now, or I'm going to wait for my wife to get home. But I still remembered the child was there. And that's what's hard for me to believe, that she would just completely forget within 15 minutes and then be having, I think the biggest thing for her is the contact she made with the mom. How do you have text message contact with the mom and then say, wait a minute, I forgot? So I think the defense is in a bad position here in this case because of those messages. So once you remove the idea that, we don't have a situation here where this woman completely forgot the child was there. And the question is, what was the child doing in the car? And if you go, if you get to the point, well, no question, Cindy, but this is a different scenario than a parent forgetting a child in a car. This is a scenario, and the extra level here is she's talking to her client, telling the client that this lady has left. So at that particular point, she's already in the house. She's already had conversations with the client. So if you're texting the mom, oh yeah, she just left, that means She's texting her for a reason, which means she consciously probably knew that child was out in the car, which now means she's guilty of all of those charges. Because once she made the conscious decision, the reckless decision, to leave the child in the car to sleep and thought, well, I'll go out in a little while and go get her, and then she gets distracted. I believe the part about getting distracted is true. Did she intend to kill this child? Absolutely not. But what I think she did is she was in a rush and she wasn't wanting to. She knew it was a tight day, and she raced inside and thought, I'll come out and get her. She's sleeping. It's cool. I'll come out in a minute. And she was inside that house and she sent text messages, and then she got involved in her day. And then all of a sudden it's 1 o'clock and she never went back out and got the child. Unfortunately, that's criminal. Unfortunately, that's negligent. And unfortunately, she's going to get convicted of aggravated manslaughter. Now, the only question at hand is, should she go away for life? Now, I don't believe she should go away for life in a circumstance like this, because I don't believe she intentionally intended to kill anybody, although her actions were reckless, negligent, and she's going to have to be punished. Now, one of the problems in working out a plea bargain in a case like this is she posted bond, and the judge set an unusually low bond. It was only $25,000, and he did that because he said, well, this was not a red rum charge. You know, they didn't charge her with like first degree or second degree. Now she's charged with third degree now, but it's a low level red rum. So as a result, she got out, and that makes it very difficult when somebody's sitting in the comfort of their home and the prosecutor's saying, well, we're going to recommend 20 years. And she's like, 20 years, 20 years from now, I get out from prison, I think I'll go to trial. It seems like a lifetime. But when you do something like this and you take a life of a child because of this type of reckless and negligent behavior, there is a consequence for it. And unfortunately, that's what happens here. But I think what's going to hang her in this case, it's what would convince me if I was on that jury, is those text messages between her and the mom. That's the end of the story. If she wouldn't have had those messages, I think it's conceivable to everyone that she could have been on that path. She's in a rush and she just completely forgets the child's there. But then why are you texting her mother right after the client leaves? And she had to have known that baby was out there. There's no other reason for her to be texting the mom and letting her know she left, which tells me that she knew that child was in the car. Now, I don't believe she was leaving the child in the car for, thinking it was going to, for any reason like that. But she left the child in the car, I think, thinking baby's sleeping. It's like there's the dad out in Arizona, who decided to leave his child in the car to go play video games, which is completely reckless and negligent. And that family is going to have to deal with the fact that, yes, he will be punished for that because it was reckless, negligent behavior that led to and resulted in the death of a child. Now, he's going to probably plead guilty. I'm sure that's what his defense is going to be. Well, no, Cindy, I understand that, but you're failing to see what I'm talking about here in terms of there's parents that leave their children in the car all the time, but there's also a difference that if you consciously leave the child in the car, like what I'm saying happened here, which is this wasn't a scenario where she just, I forgot. And the reason why I say that, what I am stuck on with this is the fact that she was conscious enough to text message her mother at 8:07, I believe it was 8:17, or maybe it was like 17 minutes after she left. So why is she texting the mom? She had to have known at that point that baby was in the car. So the question would be, why would she be in the car? I don't believe it was to kill the baby, but I think it was because the baby was sleeping and she thought, well, I'll come out and get her in a moment. And as any parents know, sometimes you make stupid decisions like that and nobody knows about it because you go out and you remember the child's there. In this case, she's got, I believe, 3 other kids in there she's babysitting. And she goes in and she makes that text message and thinks, I'll go out and get her in a moment. And the next thing you know, it's whatever the heck she was doing that day. There's also an insinuation in this case that she might have been under the influence of some sort of substance. And that was what the point of the fact that she called, that when the mom called her, she said, what door are you at? And this mom had always come to the front door. So if that's the case, then you really do have some problems because once again, we're right where we need to be, which is negligent behavior. She's going to babysit children that are, that would be completely negligent. And that's the point. She failed on her duty of care to the child, which is how you get to aggravated manslaughter. And she definitely failed on her duty to this child, no question about it. The only question is was it an accident or not, in terms of if she truly, genuinely forgot that the child was in the car and then got there and then just went inside and went about her business, then she's not guilty of a crime. It's an accident. And I understand we all want to punish, but it's like the idea when you get in a car accident happens and, people are like, somebody lost their life, and maybe the family of the people that lost their life says, I want that person punished for life. But in reality, the situation was it was an accident, and it wasn't a scenario where someone was drunk or speeding. It was just an accident. It was just a bad set of circumstances where the roads were slick. No one's going to jail for that. But in this case, I think she's going to prison. I think she's going to get convicted because of those text messages. If those text messages didn't exist, then I think there would be a strong case to be made that it's possible. It's certainly no proof beyond a reasonable doubt, and that is the standard here. They have to prove beyond a reasonable doubt that she was aware that that child was in her car and she made a conscious decision to leave the child in the car, which is why this is not an open and shut case. And that's where I started this discussion from. But I believe those text messages are going to be the biggest problem for the defense. Now, her testimony was quite convincing. Yes, Christine, I think she's going to be found guilty. I do. Now, I could be wrong. This jury could have been moved by her testimony and said, hey, you know what? I really genuinely believe this woman made a mistake. Or they might not care. They might look at this and say, you know what? Okay, we've all made these mistakes. Again, it's just a matter of the jury of what this jury does, because this jury might go back to that room and say, you know what, I'm not going to, even if she did that, right? She still at the end of the day forgot. There wasn't an intent to kill the child. So let's just say she goes and says, okay, I'm going to leave the child in the car to sleep for a little bit and get in here and get settled, and I'll come back and get the child. She never does. She already testified yesterday, Christine. Then she may, for some, there could be a juror back there that says, you know what, that's not enough for me to go convict her of all these charges. But I think in the end, when you have a 10-year-old child that baked to death in a car, or not 10-year-old, 10-month-old child that baked to death in a car seat in the hot Florida sun, I'm sorry. I mean, I'm going to convict her. That's what I'm saying. Exactly. That's what I think, Kenya or Kenya. Absolutely. I absolutely, that you're right. And then that's what I'm saying. She said the child was sleeping when she got in the car. But then, like I said, and couple that with the fact that she's texting the mom right after her client leaves, or the other client leaves, and she's letting the mom know she just left, and they're making jokes. She consciously knew that child was in the car. She consciously made that decision to let that child sleep in the car, and that was a very bad decision. And it was a decision now that has had unbelievable consequences for the mother and father of that child, and of course herself. And it's sad. It's terrible. It's completely tragic. But it's also, if you are going to care for someone else's child, then you've got to do everything you can to make sure that you're doing what you're supposed to do. Now, again, conviction on those charges versus what is the sentence that I think she should get is a totally different thing. I don't believe she should go away for life. I just don't. It was completely reckless. If I was the judge in this case, I would feel very comfortable giving her a 15-year sentence, or some variation of a 15-year sentence, which I believe in Florida, the minimum you serve on manslaughter, if it's a worked out plea, is 9.5 years. So I would say 9.5 to 15 years would be a great place to start for this. I mean, some might think, there might be others that think that's too little. Some might think that's too harsh. But I think that, you took away this child's life. I mean, it's not ideal, but I think that would be still give this woman some time with her family, time to heal. I mean, she's also going to carry around the weight and burden of having done this, which is going to be, that cannot be discounted at all, either. I'm sure she was, but I'm sure, like I said, it's very difficult to move someone into a plea deal that involves a significant prison term when they're out on bond, like she is, and you're sitting at the comfort of your home. Like for her, this thing is there, but it's not real. It's like, it's there, it's looming in the background. It's court dates. There's this potential there, but there's also this belief at this point where it's like, well, it's going to work out. It's going to work out. But the reality of the situation is it's this is a case that is a very, 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 very serious case. Kenya says, I think she noticed the baby was sleeping and didn't want to wake the child. Maybe she said to herself, I'll come back and get her once I get settled, and maybe then forgot. But a child is absolutely. Can I? That's what I believe absolutely happened. You hit the nail on the head, 110%. That is what this case is, and to me, I believe that this would have been better served because, see, unfortunately, in Florida, when you take a case to trial, that works against you in the sentencing because you put the state through an entire trial, you put the family through an entire trial, and there's expensive trial and everything else. So I think this would have been better served as an open plea situation. Even if it was an open plea, if you don't like what the prosecutor's recommending, go before the judge, testify, have a full hearing, bring in the experts to explain how something like this can happen. And that's what you got to do. Yeah, behind the passenger seat, absolutely. Now, I have multiple, like I said, in fact, it's funny you should say that, Tarina, because I was thinking the other day, right? I have, as I mentioned, I have 2 older kids and 2 younger kids, right? So right now, my youngest middle child is sitting behind the passenger seat. And I was already thinking the other day, because of this case, I thought to myself, you know what? I've got to move the car. I got to switch the car seats because I never did that. But I thought, that's where you want the baby to be at because, of course, the youngest middle child, I mean, when he's in the car, you're not forgetting him, and that's where I got to move it. Now, my wife's car, that's where we have the baby at, is on that side. So the baby's on that side so she can see it, and we have the mirror there as well, one of those mirrors that you can see right down because, of course, the baby's rear facing now. So, but it is, but I got to do that. So that's definitely got to happen because I could not imagine. It would be absolutely just unimaginable thing to forget your child. Although I just don't know how you would do it, but parents do it all the time. That's why at Walmart they even have an announcement when you're walking into Walmart on the sound system. Make sure you check your kids, check your car. It happens. So it's one of those things that it's just unfortunate. So it looks like court is running a little late this morning, and I guess it's going to run. It was supposed to start at 9:30, according to this judge, but he was indicating that there were some issues they had to work out, which I believe is probably having to do with jury instructions and whatnot. And I'm sure there's a big fight over it because jury instructions will make a big difference in this case. Because they're going to be what the defense is going to rely on to try to argue to the jury that what they've heard in this case is not criminal. And the state's going to say it's criminal. But I think for me, the only thing that matters right now in this case is the fact that she picks up this child. Like 17 minutes later, she's arriving at the house. The child was still asleep when she picked it up. The mom communicates that. She's communicating with the mom, which tells me she had an awareness that child was there. If the awareness that the child is there, that means she made a conscious decision to leave the child in the car, which is absolutely negligent. And from there, we apply that action to the charges, and it's going to meet the elements of those charges. The duty of care was not met, and as a result, she's going to get convicted. So I don't believe this will be a lengthy deliberation. It could be. I don't think it will be. I think it's going to be maybe a couple of hours, and I think we'll have a conviction definitely by the end of today. Might be in the evening time. It just depends on how long it takes them to get through closing arguments and all of that stuff. So that's where we'll go from there. Now, on the other side, I'll be starting that trial here momentarily. We have the McKinley Louisma trial. So check that out as this one is ending. That seems like it's going to be our last one. All right, Beatrice Guzman says, nope, there's no proof that she intentionally left that child. The conversation on the phone did not trigger because not the mother nor the defendant spoke about the child. Well, Patrice, though, it's not that she spoke about the child, but it's the fact that she spoke about the client at the house where she headed with that child. So there would have been no reason for her to be texting that mom about, hey, she's left. This lady left and is leaving now, or whatever the joke was, which I guess I'm assuming may have been she was leaving later than what it was. But it's when you take it into a culmination of the events, that's showing the awareness that she's there. Why else is she texting that mom? There's not evidence that she's texting that mom about on a daily basis of just about generalized things. So I don't think it's going to get lost on the jury that 17 minutes before that text is sent, she's picking up that child, and then she's texting that mom, because that's pretty much like I've arrived. Well, that's what I'm saying, Marmalade, and I don't think there's any. I mean, now again, that does not mean that there's not a juror back there who's going to say, I'm not interpreting this as criminal behavior, and they just say, I'm not convicted. I mean, that's possible. Even saying, hey, she forgot the kid in the car, or made the conscious decision to leave the child in the car for the nap, and says, well, that's not criminal behavior. She still forgot. It is technically, but the juror doesn't have to find that it is. Michelle Smith, I don't recall if they got deep in. I know she was on Snapchat because she was responding to Snapchat messages. So, but her cell phone usage, I don't believe, was anything out of the ordinary. Besides, they made a big deal. They were allowed to admit the Snapchat portion of it, that she Snapchatted the aunt of the baby, and made a comment on a Snapchat post that the aunt put up, which again should have triggered the baby was there. So to me, but again, you have to remember too, that's taking her at face value that she just simply forgot the baby was with her. I don't think that's what happened here. I think she made the decision, as some would, to think to herself, I'll come out and get the baby in a minute. Because the baby's sleeping, she's in a rush. And again, many people do things like this that never get caught because stuff like, it doesn't happen. And again, given the fact that she's there as a capacity as a babysitter, she's texting about the other client leaving. It's pretty much a text like, I've arrived and we've made it safe. That tells me she was aware that child was there with her, but at that moment, the child was sleeping in the car and she was just getting things started, and she had every intention of going back out to go get the child. And then unfortunately, that didn't happen. And that is a problem. And that is where that is a negligent decision. And if the child dies because of it, guess what? You're going to jail. I mean, in the event that a jury convicts you. Now, there's no question. Now, the defense did a good job presenting the fact that this was a very responsible babysitter. This is a sought-after babysitter. I don't remember, Michelle. I may have missed some of that because I've been in and out on the case because I was also checking out the burning husband trial, or the burning wife trial, the one that the husband put the wife in the fire. So there's a possibility that I may have missed a detailed discussion of her phone activity. Just re-listen to Stacy's testimony. Yeah, that would have been a great question, Hannah B, because and maybe it's one that neither side wanted answered, but that's a great question, because again, like I said, this is believe it or not, people do stupid stuff like this all the time. All the, and they never get caught because nothing bad happens. It's the one time something bad happens that all of a sudden, oh, you made a huge mistake here. And in this case, she made a tremendous mistake here. Again, why there wasn't a negotiated plea here, I don't know. The only thing I can think of is that obviously either the defense really believe, might know might really believe that they're going to have a jury here who's going to favorably view this case for the defendant under the circumstances, and just said, it's not necessary. But I can't imagine why you wouldn't have tried to negotiate some sort of a plea bargain here. And it's also possible, too, that the parents of this child are so upset over this that they said they don't want to have a plea bargain, or whatever the plea bargain was. It was, like I said, the top. You got to understand, in this case, the max sentence is life. So the state, I'm sure, is not coming and offering 5 years for this. They were probably offering 25 years. And this lady was probably looking at that and saying, hell no. I'm not, I'll go to trial first before I take something like that. So, Cindy Braddock, absolutely. That is 100%. I do that all the time. That is the first one that comes in the house. First thing I do is I walk around. I let my 4-year-old out of the child seat so that he can get out of the car. Then I walk over to the baby before I take a grocery in, a bag in, anything in. The baby comes in, and I put the baby right over there by the door so that I know the baby's in and safe. No way in the world am I ever leaving the baby in the car, for any length of time, because it just, you heard in this case, I was rewatching the medical examiner's testimony, and he was saying that, it only takes 20 to 30 minutes for the child to burn up in the car, and that type of heat. And that can be in as little as 72-degree weather. So Hannah B says she contradicted what she said in the police interview. She said she thought the baby was asleep on the stand. She says she forgot the baby was in the car when she arrived. I know, and see, but that's because Hannah B, she was trying to put space in between the idea that she because what she did in this case, 110%, in my opinion, is that baby was asleep, and she just made a decision to leave the child in the car, and it was a really stupid one. And she was intending to come back out and get the child. Oh, Christine Fortunato, thank you for the information. See, it was 30 years. So the plea bargain in this case was the state was going to recommend a sentence of 30 years. So I'm sure for her, she said absolutely not. Maybe you should go back and watch all. Well, that's what I said, Beatrice Guzman. I was saying that I did not believe that was what had come out unless somebody was going to tell me they saw something. The only reference I saw in the case was the Snapchat text or response to a post on Snapchat. But otherwise, it seems he was a responsible babysitter to those other children doing what she normally did. But Beatrice, you have to understand that what I'm saying is that the fact that she was texting that young mom, so you show me where in this case, please point me in the direction to where they showed that they had a long history of texting each other on days that she wasn't caring for her child, that they had a long history of sharing text messages and things. Perhaps it's there. Perhaps that would make sense. And that's something that would have to definitely be shown. I'm sure if it's there, the defense will talk about it in their closing. But I believe that the text that she sent that mom at 17 minutes after she picked up her child was driven because she knew that child was there, and she had made a conscious decision to leave the child in the car. And I don't believe she intended to kill the child. But I mean, it's just that simple. But like I said, she she is a very sympathetic figure, because I very genuinely believe that she feels terrible about this. I've seen people claiming she was fake crying and all that stuff. I don't believe it. I don't believe there was any evil intent in this instance. I believe it was just a poor decision that many people would never connect with ever resulting in what happened here. And it's why you just don't take those chances. It's why the child always comes in, and that's what has to happen. Now, what I don't understand, okay, this is what I thought. Again, I need to go back and rewatch that, but I don't believe, because I saw it come through. But what I don't understand is, I would imagine you would have thought that the client's house that she was watching these other 3 kids at would have been aware that that baby was coming over, right? So why didn't the client say, "Where's the baby at?" Well, I think Hannah B, she did refuse a drug test because there is some insinuation that she was taking some painkillers, possibly, that had to do with a shoulder injury. But so it's possible, like I said, that could have been a factor, because there is that suspicious situation that said, why did she not know that? Why did she ask her what door she was at? So if she was on some sort of a substance, then that's even worse. Mary Jo says she didn't always have the baby with her. Well, I understand that. But again, the connection between picking the child up and then texting the mom, I think, with this jury is going to be damning. And then the fact that I do believe, and again, I'm not 100% certain, I've just seen it circulating, so I'm assuming it was included in the trial in part of the police testimony when she gave her statements, that she was asked to take a drug test and she refused. I don't know if that was allowed to come in or not. If it was, and they allowed that to be used against her, then that's going to be damning. And then that jury is going to convict her. I think she's going to get convicted, and she's going to be in trouble. So anyways, guys, I've got to get this other trial started, so I'm going to jump out of here. This trial should be starting, well, it's 35 minutes late, but it should be starting any time now. So we'll see what the defense has in store for us today in their closing. We'll see what the state has in rebuttal, if anything. And then we'll see what the jury's verdict is, because I believe this jury will have a verdict today. I don't believe this will be an extended deliberation. Now, if it is an extended deliberation, that will be in favor to her, but I don't believe it will be. Marmalade, good to see you as well. Good to see everyone in there. Cindy Braddock, great to see you. Hannah B, as always, thank you for coming in and sharing your great thoughts and insights. Mary Jo, great to see you. Sarah, thanks for seeing you and coming in. I appreciate you being there to moderate and remind everybody to hit that like and subscribe button. Christine, great to see you as well. Michelle Smith, Beatrice Guzman, thank you for coming in and sharing your thoughts. Tarina, first time I've talked with you. Nice to see you. Thank you for sharing your thoughts. Kenaya, thank you for coming in as well. And with that, guys, I'm going to jump back down in the corner of the deal here. I'll be watching you on mobile. I've got to hit the road here. I've actually got to go up for the second time this week to go grab my son from college, because I've got my sister coming in from California this weekend. So I'm going up to grab him for the second time. First one was to bring him back to vote. And this one's to come back for family. So I'll be on the road listening as I drive. So I will see you guys soon. I'll talk to you guys soon. Tune in tomorrow for the podcast with myself and Defense Rest. It's called On the Record. It's our second episode. We're going to be talking Ferris case. We're going to be talking Lewis. We're going to be talking this case, and it'll be fun. It'll be at 9 a.m. tomorrow. So check us out, and I'll talk to you guys soon.